Morning, 11:33 a.m. Eastern Standard Time on this Friday, August 4th, 2023. I'm XRP Future Millionaire, and I reside in the great state of Michigan. So in my quest to bring you all the news that is breaking that could have any kind of impact or is in relation to the fight against the SEC, COINBASE has filed its memorandum in support of its motion for judgment on the pleadings. They've essentially compared their trading crypto to trading baseball cards, so they feel it's not a security. But they actually filed a 36-page official document here. And we're not going to go through the whole 36 pages. I'll show you the very beginning of it in the brief. And then I'm going to go over an article that breaks it down so that we don't have to go through the 36 pages now because it would take forever. And this isn't an XRP thing. So today, Coinbase filed our brief asking the court to dismiss the SEC's case against us. Our core argument is simple. We do not offer investment contracts, as that term has been constructed by decades of Supreme Court and other binding precedent. So then you go into here, then you download the file, and now you open it. And we got United States District Court for the Southern District of New York. This is a 36-page official document filed on August 4th, 2023. Actually, it's a 38-page official document. And it's United States District Court for the Southern District of New York, Securities and Exchange Commission, Plaintiff Coinbase Inc. and Coinbase Global Inc. defendants. So you look at it, it was filed in New York, New York. This memorandum of law in support of Coinbase's motion for judgment on the pleading. So I just want to go through the beginning. The complaint does not plead securities transactions. It just shows you the entire thing. So you have an argument on page 5, background, preliminary statements, table of authorities. So what I want to do is go to page 5 for the argument. And then when you look at it, it's just filed like this. It's not a whole bunch of writing until you get to page 8 with preliminary statement. So this is all we're going to read is the preliminary statement. So 2 years ago, recognizing that the SEC wanted but lacks statutory power to regulate crypto exchanges, Chair Gary Gensler asked Congress for a legislative mandate. None came. Now, without any intervening legislative act, the commission issues Coinbase, the largest U.S. crypto exchange, of having defied the federal securities laws and failing to register as a security exchange broker and clearing agency since 2019. No matter that the SEC allowed Coinbase to go public in 2021 with the same business it operates now, no matter that Congress has for years been actively considering and just last week advancing legislation to grant and allocate among other regulatory agencies, the very authority the SEC now claims for itself. The SEC wanted to get the jump. In making that jump, the SEC has violated due process, abused its discretion, and abandoned its own earlier interpretations of the securities laws. But there is a more fundamental problem with its case. One, the chair recognized 2 years ago, and that entitles Coinbase to judgment on the pleadings now. The subject matter falls outside the agency's delegated authority. The SEC may pursue this enforcement action only if relevant transactions in the digital assets and services identified in the complaint are investment contracts, and therefore securities under the Securities Act of 1913, the Securities Act, and the Securities and Exchange Act of 1934, the Exchange Act. Because as a matter of law, none of them are. The claims must be dismissed as indispensable feature of the investment contract as defined by the Supreme Court and SEC v. W.J. Howie in 1946 and by the state securities law jurisprudence that grounded Howie is that the lease purport to grant the purchaser a contractual right to profits, income, or assets of a business enterprise. The SEC does not and cannot allege that transactions in the 12 tokens identified in the complaint that take place on Coinbase's secondary market, spot exchange, or on the other secondary market exchanges through Coinbase Prime carry such rights. They are asset sales with the obligations of buyers and seller discharged at the point of sale. Where there doubt on this score, the major questions doctrine would require dismissal and deference to Congress's prerogative to decide how to establish and allocate authority over the digital asset arena. Now, does Coinbase operate as a broker of investment contracts by making wallet software available to users? The token that the SEC says customers can self-custody using Wallet Nexo is not alleged to carry any more rights to share in any enterprise than the other 12 tokens identified. Even were it otherwise, the complaint pleads nothing to suggest that Coinbase functions as a broker under the securities law by making available to users free software allowing them to store and access their own digital assets on their own computers or devices. Finally, the SEC's claim targeting Coinbase's staking program fail as a matter of law because, one, the facts pleaded and incorporated by reference established that staking service customers makes no investment of money by staking through Coinbase software, and two, or staking customers receive ministerial as opposed to managerial services from Coinbase. So that is the preliminary statement given out by Coinbase. You can go read this 38-page document on your own. Go to Twitter and look up Coinbase and you'll find it very easily, or James K. Phelan. But now I just want to go over this very quickly so we can get an overview of it very quickly. Breaking: Coinbase files for U.S. lawsuit, SEC lawsuit dismissal. Coinbase on Friday filed a brief before the judge in the Securities and Exchange Commission, SEC lawsuit seeking to dismiss the case. Crypto news: United States-based crypto exchange Coinbase on Friday filed a brief before the judge in the Securities and Exchange Commission, SEC lawsuit seeking to dismiss the charges. In its brief, the exchange argued that it does not offer investment contracts in a way that it is not interpreted by decades of Supreme Court rulings. The development comes at a time when the U.S. regulators and politicians face increasing pressure to bring clarity to crypto market laws. So SEC deviated from prior interpretation of law. Attorneys representing the crypto exchange filed a memorandum of law in support of Coinbase's motion for judgment on the pleadings before the United States Court for the Southern District of New York. They argued that the SEC violated due process and abandoned its own earlier interpretation of the securities laws. By ignoring that precedent, the SEC has trampled the strict boundaries on its basis authority set by Congress, said Paul Grewal, the chief legal officer at Exchange. Similar to XRP lawsuit, the attorneys also explained that agency's effort to portray a simple asset sale as a security is an unprecedented stretch. Interestingly, the attorneys referred to the XRP lawsuit ruling, saying the Ripple court found no investment contract based on facts substantially identical to those alleged here, claiming that the SEC's complaint does not plead the required elements of an investment contract. The SEC's Exchange Act claims should be dismissed. It said in the latest filing in June 2023, Coinbase and Binance were subject to SEC lawsuits over alleged violations of securities laws. Earlier on Thursday, the exchange reported its second quarter earnings beating Wall Street estimates. Meanwhile, Coinbase coin stock price is on a downward trajectory in the last few days. Make sure you hit that like button if you appreciate this content and this information, and make sure you hit that subscribe button if you appreciate my work.